Frances, you do realise that we're all still watching, don't you?
It's time for you guys to start being journalists.
Before an angry Andrew Baldwin left the courthouse, 13 News overheard him speaking to Richard Allen's wife, saying, "It ain't over. The world's watching. The world sees what's going on."
Good morning everyone, my name is Michelle. I hope you're doing well. Welcome to another video. It is Tuesday morning, the 23rd of January, and we are discussing the Delphi case today because Judge Frances C Gull has been added again. Oh yes, it's game on. It's game on. So what has she been doing this time? Well, some of you will have seen this, but I'm going to go through it in detail. We're going to break it down. This is the order that Frances C Gull issued yesterday, the 22nd. The court, having had defendant's motion for Frank's hearing, filed September 18th, 2023. The memorandum in support of the accused motions for Frank's hearing, filed September 18th, 2023. Defendant's supplemental motion for Frank's hearing, filed October 2nd, 2023. Defendant's additional Frank's notice, filed October 3rd, 2023. So we're going to stop there because that's all the stuff from September and early October, which took Richard Allen all the way to the Supreme Court of Indiana. And if you need to brush up on all what happened there, then go back and watch some of my recent videos. But we're going to break this down step by step so that it's clear for everybody. So the Frank's motion was that big memorandum, which was 136 pages, that I spent hours and hours and hours on live streams going through, reading it all, commenting on it all. And it was all for one purpose. That was to get the search warrant thrown out. For those not familiar with what a Frank's hearing is, this is what a Frank's hearing is. It comes from a case from 1978, Franks versus Delaware, Franks being the defendant, and it went all the way up to the Supreme Court, and that set a precedent that's used to this very day. A Frank's hearing is a legal proceeding in a criminal case where the defense lawyer attempts to traverse a search warrant. So the defendant challenges the truth of the information used to support it. So in Richard Allen's case, his defence, Bradley Rosie and Andrew Baldwin, in that Frank's memorandum and all of that supporting documentation, said that the cops lied or concealed information in order for Judge Diener, who was the judge at the time, to sign a search warrant. Okay, so that's what all of that was that was filed on September 18th. And just to be mega clear, this motion is like a condensed version of what the defence were arguing. The accused Richard Allen, by and through counsel Andrew J. Baldwin and Brad Rosie, files for his request to this court to set a Frank's hearing. In support of said motion, defence counsel states that on October 13th, 2022, following a roughly hour and a half interview with the accused, Richard Allen, Detective Tony Liggett, who is now the sheriff, signed an affidavit for search warrant, which was a 5-page document detailing information concerning said interview with Rick Allen, as well as information flowing from a 5.5-year investigation into the murders of Abigail Williams and Liberty German. The affidavit for search warrant was also approved by a second signatory, prosecutor Nicholas C. McClelland. Slick Nick Charles McClelland. before being sent to Judge Dina for further review. The purpose of said affidavit for search warrant was to provide a sworn statement containing information from that lengthy investigation that would convince Judge Dina that a reasonable belief existed that evidence of said murder would be found in Rick Allen's home and vehicles. The affidavit for search warrant was apparently reviewed by Judge Dina, who then signed a search warrant for Rick's home at 6:37 p.m. on October 13th, 2020. That should be 2022. That on its face and within the four corners of the document, the affidavit for search warrant was defective in that it did not provide the type of information that would cause any reasonable person to believe it was more likely than not that evidence of the murder of Abigail Williams and Liberty German would be found in Rick Allen's home or vehicles, especially more than 5.5 years after they were murdered. Because, on its face and within the four corners of the affidavit for search warrant, no reasonable person would believe that it's more likely than not that evidence of the murders of Abigail Williams and Liberty German would be found in Rick Allen's home or vehicles. Judge Dina erred in signing the search warrant. Therefore, any search of Rick's home and vehicles was illegal. Therefore, all items seized pursuant to said illegal search should be suppressed. However, and this was all what went into in that 136-page memorandum, making matters far worse, Detective Tony Liggett chose to hide crucial information from the search warrant affidavit and provided false statements in said search warrant affidavit. The defence is required to make a substantial preliminary showing that omitted or false statements were made knowingly or intentionally or with reckless disregard. If the trial court concludes that omitted facts or false statements were necessary for the findings of probable cause, then the trial court should set a hearing on the defendant's request. That's Franks versus Delaware, 1978, that I mentioned before. So they should have a hearing if the defence has reason to believe that the affidavit contained false, erroneous statements that could be proven false factually, then there should be a hearing. Right? That's what they're applying for. There should be a hearing. Indiana courts have held that when material information is omitted from a probable cause affidavit, such omissions will invalidate a warrant if 1. The police omitted facts with the intent to make the affidavit misleading or with reckless disregard for whether it would be misleading, and 2. The affidavit supplemented with the omitted information would have been insufficient to support a finding of probable cause. Rather than hiding said information from Judge Dina, had Liggett actually included said information within the affidavit for search warrant, then Judge Dina most certainly would not have signed said warrant, as the hidden and false information was the type of information that any reasonable person would have known was the kind of thing the judge would wish to know. If the judge knew what the cops were concealing, then he wouldn't have signed it. Therefore, Rick believes in his memorandum in support of his motion for Frank's hearing, which details the long list of specific information in the search warrant affidavit that Liggett chose to hide from Judge Dina, as well as information contained in the search warrant affidavit that are flat-out falsehoods that Liggett swore and affirmed were true. The defence would ask the court to incorporate the attached memorandum in its motion. Once the court has reviewed the motion for Frank's hearing, the memorandum in support of the motion for Frank's hearing, as well as all the attached exhibits that support the memorandum, Richard Allen, by and through counsel, would ask this court to set this matter for a hearing, in which the defence will be arguing that the search warrant was illegal. The defence will be requesting the court to suppress all fruits of the illegal search. So they're applying for a hearing. They're not applying flat out that all of that search warrant stuff should be thrown out. They're applying for a hearing to discuss it. That's it, that's all. I'm not going to read all of this, but this is the affidavit for the search warrant that they're talking about. So you will note in this documentation, one of the things that Frances claimed meant that she needed to just get rid of the Frank's hearing and all mention of it from the docket was because they admitted to blank out the names of Abby and Libby. Well, this is Liggett's own work here, which is available on the court docket, and hey presto, the victims' names are mentioned, as are all the witnesses. All the witnesses, look, all of them. Anyway, that's the document. So it's basically the probable cause affidavit with no redactions, and it is signed by Tony Liggett, Nicholas McClelland, and then at 6:37 p.m. it was signed by Judge Diener. So that's all what that relates to. Further, the state's objection to defence's motion to suppress, filed June 13th, 2023. That is this, the motion in limine that was filed regarding the ballistics. So what's a motion in limine? A motion in limine is decided by the judge outside of the presence of the jury. The purpose of a motion in limine is to address potentially prejudicial, irrelevant, or inadmissible information that could unduly influence the jury or hinder the fair admission of justice. And the most common use is to exclude irrelevant and or prejudicial elements. So what the defence wanted was to get rid of the ballistics information. So this is the ballistics information by the Indiana State Police. And these were the items that were tested in the lab. Now remember, in the memorandum, the defence stated that there is a loss of chain of custody. Although the ballistics, that unspent round, was found in the ground and there's a picture of it in the ground, then the next picture along is the picture of it in the lab. So what happened to it between being in the ground and being in the lab? So they're also arguing that there's a loss of chain of custody with this. But this particular document here details the examination. The stuff regarding Rick Allen's gun, the Sig Sauer P226, which was judged to have expelled the unspent round found at the crime scene. So they took to the lab all the stuff that they found as a result of the search warrant. So the defence wanted all of this thrown out. Remarks: an identification opinion is reached when the evidence exhibits an agreement of class characteristics and a sufficient agreement of individual marks. Sufficient agreement is related to the significant duplication of random striated or impressed marks as evidenced by the correspondence of a pattern or combination of patterns of surface contours. The interpretation of identification is subjective in nature and based on relevant scientific research and the reporting examiner's training and experience. It is a subjective process, but it is backed by some science. All right, it's contested science, but there is science nonetheless to indicate that bullets that come from a particular gun have individual striations or impressions to show, subjectively show, mind you, that that bullet came from that particular gun. Now, the science is even more contested when the information comes from an ejected but unspent round that wasn't fired. If I understand the science correctly, the firing itself creates individual marks that are easier to determine are from a particular gun than if that entire round was expelled from that weapon without being fired. But that's what they wanted to be removed. And the state's second objection to defendant's motion to suppress, and that was filed in September. She took all of that stuff about the ballistics under advisement, but then never ruled on it. So she had all this Frank stuff to get rid of the search warrant, plus all the ballistic stuff that she'd taken under advisement. Now she's ruling on it. Dun dun dun. Now denies the defendant's motion for a Frank's hearing. So she's saying, no, you can't have a Frank's hearing. You can't have one. So all they were asking for in that memorandum was a hearing under Franks v. Delaware, 1978. But she's saying, no, you can't have a hearing. You can't even present your information in court. You can't have it. The court finds the affidavit submitted in support of the issuance of the search warrant, so that's by Tony Liggett, contained information that a reasonable belief existed that evidence of the murders would be found in the defendant's home and vehicles. So what is she saying here? She's saying, you're not even allowed to present your evidence. I've just decided. She's at it again. She's at it again, just deciding, without any hearing. She's learnt nothing. The search itself was reasonable and legal under Indiana law and Fourth Amendment case law. Defendant's motion to suppress fruits of search from 1967 North Whiteman Drive, Delphi, Indiana, filed May 19, 2023, is also denied based on all pleadings, memorandums and exhibits previously submitted in support of the request for a Franks hearing. So that's that one. Motion to suppress is also denied, so that's all denied. Defendant's motion in limine regarding ballistics, filed June 13th, is reviewed and denied without hearing. So no hearing on that either, just denied. The court finds the evidence contained in Defendant's Exhibits A and B attached to the motion is relevant and admissible. The court further finds the probative value of such evidence is not substantially outweighed by its prejudicial impact, and that the evidence will not confuse or mislead the jury. In her opinion, there's been no hearing. There's been no hearing. She's at it again. The defendant's motion to transfer, filed January 12th, 2024, is taken under advisement pending the state's response. So this was filed by Scremin and Labrato. And this is getting Rick Allen transferred from a state prison where he's currently being abused in Wabash to a county jail. So she's taking that under advisement. She wants to know what Slick Nick feels about that. Well, Slick Nick will feel that, oh, he's all fine and dandy. And then my prediction would be that she'll say, oh, well, Slick Nick thinks it's okay, therefore it is. Okay. All right. So, if any, and a hearing will be set. The state's motion to amend information filed January 18th will be set for a remote hearing. So that will go for a hearing. So that will have a hearing because Slick Nick did it. So that's the upgraded charges, which we talked about in a previous live stream. So, yeah, at it again. What can you say? Unbelievable. Absolutely unfreaking believable.